Bill, I'd like you to think back to many, many years ago when you first started off with the prosecutor's office. And I assume after you kind of got your feet wet, they put you on a trial team. Is that right?
In due course, first grand jury, juvenile, motions, then you finally got on a trial team.
And I would imagine, going back so many years ago, that you were pretty much in trials all the time. Wouldn't you say that's pretty true?
And there were more trials then than there are now.
And that's my point. I mean, it seems to me that many, many years ago, not only you, but the entire office was involved in trying cases constantly. I imagine if you're on a two-person trial team, one week you'd be in trial, the next week you'd be off preparing for your next trial. Wouldn't that be pretty close to the truth?
And generally, while the first person is in trial, you're prepping for the next one.
And you would always want to have a jail case left over in case your first case fell through.
Absolutely.
Because your jail case, at least you know the defendant's going to show up, right?
You didn't have to go look for them.
Now, we've got to go ahead now into the new century, which is where we are firmly ensconced at this point. And that's not the reality of criminal practice today, is it?
No, when the new rules, which are no longer new, went into effect 10, 15 years ago, the judge, Pareca, who was running around the state selling the new plan, made it clear that the whole idea was that trials were representing a failure of the system.
Can you talk about this in a little bit more detail in terms of, because I think the people who are going to practice criminal law really have to know what's been happening, so they go into this understanding it with a much deeper context.
Well, the idea is that in a theoretical perfect world, every case should have a point at which the interest of the state and the interest of the defendant balance out, and an agreement should be able to be reached. So that whether that agreement is to dismiss the case because there's an absence of proof, or whether it's a plea bargain, every case should find that level where it should work itself out in one way or another. And if you posit that that is the ultimate goal of the system, then a trial represents a failure of that system. And as a result of that, the courts have moved to a position where what they're most interested in is the efficiency of the system, the disposition of cases, and the disposition of mass numbers of cases. And that being the situation, the number of trials has severely dropped off over time.
So are judges now gauged upon the quality of the justice they mete out, or the wisdom of their decisions, or are they primarily judged on productivity?
Nobody ever asks the judge, how wise were you today, Your Honor? What they're asked is, how many cases did you dispose of today, Your Honor? And that is really the measuring stick for what has become justice in the state of New Jersey.
So I imagine statewide, you certainly have jury trials going on, but many, many fewer than you used to have in the old days.
Many fewer, and they usually come in a couple of circumstances. One, where the defendant seriously contends that he is factually innocent of the charges, or cases where the penalties are so draconian that it makes sense for the defendant to take a shot rather than try to work out the deal because the balancing point is at an unacceptable level for the defendant.
A little bit of this seems counterintuitive to me because so many times the sentences are mandatory in nature in the sense that it requires the defendant to go to jail, and frequently the amount of the jail, especially for a violent crime, will represent 85% of the term, during which he'll be ineligible for parole.
And sometimes those terms are very high.
So, but yet it seems like many of these cases plead out also.
Many of those cases plead out because the prosecutor may well give the defendant a discount off of the going rate based upon the proof of the case, the amount of time it's going to take to dispose of the case. And again, remembering that the prosecutor becomes involved in this efficiency move of the courts as well, it doesn't make any sense for the prosecutor to insist that every case go to trial when the whole system is geared toward dispositions. So the prosecutor tends to be caught up in the flow of these cases and offer pleas in part for the purpose of inducing defendants to take the plea and make the system work.
In your experience, do judges sometimes also get involved in trying to pressure one side or the other to reach a disposition on these cases?
There's no doubt. And some judges more than others. Some will stay out of the plea bargaining process pretty much. Others will get involved even to the extent of ex-partying one side or the other, or both, to try to whipsaw them into finding that point at which agreement is necessary. And just to give you an example, you can do it very easily by by saying to either a prosecutor or a defense lawyer, look, you can go to trial with the case, but in the defense lawyer situation, if your client goes to trial and gets convicted, the plea offer is X now, but the sentence is going to be X plus whatever. If your client goes to trial, turn around, you do the same thing to the prosecutor. You can say to the prosecutor, the defense lawyer is willing to plead for 5 years. You're saying that you want 7. I'm telling you, if you go to trial, the net result is going to be, and the defendant's convicted, the net result is going to be 5 years. So the risk is all yours. You can go to trial if you want to, or you can take the deal at 5, but you're not going to get your 7.
So it's important that I think that new attorneys coming into the system understand that they're dealing with this as kind of the culture of the courts these days, and have to kind of deal with it and represent their clients, because criminal case preparation at this point really involves dispositions that are not going to involve trials in the vast majority of the cases. Would you agree?
In the vast majority of cases.
Now, my own experience lately, and this may be just because of the way the rules have things coming down, is that when I approach prosecutors in the superior court, the process, even if I don't know them, is really much more collaborative than it is adversarial. And the sense I get from prosecutors many times is, you know what this case is worth, I know what the case is worth. We're probably very close at the end to what we both think. Let's work together to get to that point. Do you find that to be true, or has that been your experience?
Yeah, and you have to understand, again, as we're talking about it, that the system almost demands that, because the system requires that the prosecutor give the best plea offer at the earliest possible stage of the case.
Right.
So that means that the prosecutor can't start off by trying to beat his or her chest and demonstrate how tough they are, because the rules require that you give your best, most lenient, most beneficial plea offer to the defendant at that earliest stage in the case. And so it actually almost works backwards. The longer the case goes, the more adversarial it gets. The faster the case gets resolved, the more friendly the process.
Now, just to kind of put you on the spot here for a second, let's say you're back as one of the bosses at the prosecutor's office, and one of the clerks walked in and plopped down 100 files on your desk, brand new files, hot off the presses, okay? At the end of the day, when all these 100 files had been resolved, how many of them would you have expected to have gone to trial out of 100 files?
Probably 10.
All right. Very, very small number. And that would be over the course of maybe 2 or 3 years.
Absolutely.
So for defense counsel out there who are undertaking criminal cases, you should do so with an understanding that the overwhelming statistical probability of the case being resolved without the necessity of trial may be somewhere north of 90%. Would you agree with that?
I would think that's definitely the case. And obviously the burden then on the defense counsel is to have some idea of where that balance point is at the time that they begin the representation of the client. At a very early stage now, the defense lawyer needs to have a representational strategy, has to know what for that particular defendant a win is. It may not always be acquittal. It may be an acceptable plea, and you have to have some idea of what that acceptable plea in fact will be. Acceptable to the prosecutor, acceptable to the court, and acceptable obviously to the defendant who's going to be the one pleading guilty.
One of the things, the way I like to think about it is that you're attempting to meet the needs of your own client, and then in your plea bargaining strategy to not only meet those needs but exceed those needs. And those needs may be minimal or no jail sentence, or diversion from the criminal justice system, or sometimes it means just something as simple as not losing a driver's license. But you also, to be successful, have to meet the needs of the other participants, the prosecutor, who certainly has needs, the judge, who has to make sure that a legal sentence is imposed and that the interests of justice are satisfied by the plea and sentence agreement. Many times you'll have victims also that have to have needs met as a result of the transaction. So I guess the secret to this is coming up with a disposition that's going to satisfy everyone's needs kind of simultaneously when the plea goes through. Would you kind of agree with that as an overview?
Absolutely. And if you don't do that, what you're going to end up with, if you as a defense lawyer take a a hard line on behalf of your client, which is unrealistic in regard to not only your client's interest, but unrealistic in regards to everybody else's interest, what's going to end up happening is you're going to get a trial for your client, and that may not be in your client's best interest. Because if your client does not really have a factual defense to the charges, you can expect that in the long run, your client's going to end up being convicted. And I used to teach the Ickle version of what we're doing now. And one of the judges on the panel used to talk all the time about the moonshot sentence.
What's the moonshot sentence?
Well, the fact that a defendant who's offered, a sentence of 5 years by the prosecutor and turns it down because the defendant is standing on principle here, may go to trial and find himself getting a sentence of 20 years in the state prison instead of 5. Because now that's not a negotiated plea. The judge isn't operating off of a pre-sentence report with a couple of paragraphs description of the case, but is now sentencing after hearing a trial, after hearing all of the gory details of what it is that the defendant is alleged to have done, now has victims who have testified, has newspapers covering the trial, and has to vindicate to some degree justice in the larger sense. That defendant may very well become the victim of the moonshot.